Before we even get into the numbers, the arrears, and the courtroom back and forth, this case already has all the ingredients of a financial pressure cooker about to explode. We're stepping into Brink versus Hildebrandt, a child support enforcement hearing where emotions are already running high, and both sides are about to clash over money, responsibility, and credibility. On one side, we've got the system laying out cold, hard numbers, support obligations, arrears, and missed payments. On the other side, we've got a defendant claiming real-world struggles, unemployment, disability applications, and an inability to keep up with life's demands. But here's the tension. Courtrooms don't run on explanations alone. They run on documentation, compliance, and consistency. And when those things don't line up, things can escalate fast. What makes this case interesting is the disconnect we're about to see. The court says one thing, the defendant says another, and somewhere in between is the truth the judge has to untangle in real time. So ask yourself as we go through this, how far does personal hardship excuse legal obligation? And at what point does the court stop waiting and start enforcing? Because once contempt gets mentioned, everything changes.
Okay, we're on the record in Brink versus Hildebrandt. This is case number 11-14050. The record should reflect that both parties on this file are connected by Zoom. Ms. Kraus, can you tell me where this file is at this morning?
Yes, the plaintiff has a support obligation of $197 and a balance of $8,512.16. The last payment was received in February in the amount of $206.47 from a prior income withholding. There's been no.
This is where things start to get legally important. We've got a direct conflict now between what the court system has on record and what the defendant is claiming happened with her address submission. And in family court cases like this, address confirmation isn't just paperwork, it's due process. If the court can't reliably reach you, enforcement becomes impossible, and that triggers serious consequences. Notice how quickly this turns into a credibility issue. One side says, "We don't have your updated address," and the defendant insists, "I already submitted it." In courtroom terms, this isn't just a misunderstanding, it's a documentation gap that can directly affect compliance status and potentially lead to default rulings. So, the real question here is this a clerical breakdown or a pattern of non-compliance being explained away? Because the judge isn't just listening to words, he's tracking consistency, records, and responsibility.
No contact from the plaintiff, and the friend of the court does not currently have a confirmed address since March of 2024.
That's not true. I have submitted my address.
Okay, when did you do that, Ms. Brink?
Just 2 weeks ago, probably. And the reason I haven't paid is because I can't get a job. Nowhere seems to be hiring in town, and everything that is hiring is Petoskey, Traverse area, and that's too far of a commute.
Okay, so how do you plan on meeting your support obligation?
I am getting in the middle of getting disability.
Okay, when are you going to know about that?
August 14th, I believe, is my next hearing date for that.
Okay, what's going to happen on August 14th?
They have to do an interview.
You what?
They have to do an interview. I'm not sure AT is going to be here to help through it.
You're breaking up. I couldn't hear what you were saying.
From when?
What is going to happen at the August 14th date with your disability?
ACT will be here to walk me through it. I don't know, other than it's an interview.
Okay, when do you think you're going to have a decision about whether you're going to qualify for benefits or not?
Hopefully after that day.
Okay, Ms. Kraus, what's the friend of the court's recommendation for today?
Based on
Now we're entering a critical legal intersection. disability claims versus child support obligations. The court isn't dismissing her situation, but legally speaking, child support doesn't pause just because someone applies for disability. It only changes if and when benefits are officially approved and verified. That's why the court is focusing on timelines here. Applications, hearings, and potential approval dates matter because they determine whether income exists in the legal sense. Until then, the obligation remains active. And this is where things get tough, because we hear uncertainty, repeated delays, and prior denials for disability. From a legal standpoint, that raises a major issue. The court cannot enforce hypothetical income. So here's the real tension. What happens when someone's financial plan is based on an outcome that may never arrive? And more importantly, who carries the burden in the meantime?
On the information that she's indicated that she's applying for disability, we do have some medical documentation forms that we could mail out to her and request that she submit and possibly adjourn out 60 days.
Okay, and what about the address issue? Do we have an address for?
I do.
Right here.
Go ahead, Ms. Kraus.
I don't have an address. If she submitted it, we don't have one. The previous address has been marked bad by the post office.
That's not true. My address has not changed in over a year.
Okay,
So-
well, I'm pretty sure.
A post office issue, that's not my fault.
I'm pretty sure Ms. Kraus isn't lying about it, so you need to make sure that you update your address with the front of the court.
Well,
And
it hasn't changed. It's still 13th Avenue, Gaylord, Michigan, 49735. That's where I received my mail also.
all right, Ms. Kraus, is that the address that the mail's coming back from?
Yes.
Well, I check my mail every single day. Don't know what to tell you. It's no longer my fault though, or my problem.
All right, well, if that's the address you want us to send stuff to, that's where we're gonna send it. If you don't get it, then it will be your problem. So you're gonna have to figure out that part of it.
This is the turning point of the hearing. The tone shifts from discussion to enforcement. When the judge starts outlining contempt proceedings and potential jail time, it signals that the court is moving from negotiation into compliance enforcement mode. In legal terms, contempt isn't just a warning, it's the court asserting its authority to enforce orders that are being ignored or not completed. The mention of up to 45 days incarceration shows how serious missed compliance deadlines can become in family court matters. What stands out here is the strict timeline. 30 days to comply, or consequences begin. No ambiguity, no extension discussed yet, just a direct legal obligation. So the question becomes unavoidable. Is this a case of inability to comply, or refusal to follow through? Because in court, intent matters, but compliance matters more. Let's break this down clearly. The court identified an outstanding child support balance, unresolved compliance issues, and a disputed address situation that directly impacts communication and enforcement. To address the situation, the judge ordered documentation related to disability applications to be completed within 30 days, with a follow-up hearing scheduled. At the same time, the court issued a clear warning. Failure to comply could lead to contempt proceedings, including potential jail time. That elevates this case from a routine administrative hearing into a legally enforceable compliance situation. What we're seeing here is a classic courtroom reality. When financial hardship meets legal obligation, the court doesn't pause the obligation. It adjusts the enforcement pathway. Now, the bigger question for you is this: should courts show more flexibility when someone is struggling financially? Or does strict enforcement protect the system from collapse? Drop your thoughts in the comments. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Mail. I check the mail every day.
Good. Okay.
So there's no possibility that it's stacked up in the mailbox somewhere. Unlike how the Hildebrands check their mail.
Okay, good. Well, we didn't have any problems then, so that's good. So we'll send the information to that address. I'm going to give you 30 days to fill out that information for friend of the court and return that. We're going to set this for another hearing in 30 days. If you fail to do that within that period of time, then the court's going to proceed with contempt proceedings, which could include incarceration. And Ms. Kraus, would this be a first finding of contempt or a second or subsequent?
I believe it would be first finding.
Okay, so you may be subject to up to 45 days in jail, Ms. Brink, if you don't fill out those papers and return those to friend of the court in the next 30 days, okay?
Talking about, I don't know of any papers. I check my mail every day. The last paper that I had to get today, I don't see in court.
We're going to send them to you at the address you gave us. You'll have 30 days to fill those out and return them to the friend of the court. If you don't, we're going to proceed with contempt and you may be subject to 45 days.
Get that.
I don't know. That's your problem, not ours. You gave us the address. We're going to send it to that address. You're not getting your
2 weeks, then I will call the court and have them resend it.
Okay. It's going to be your obligation to make sure that you get that taken care of, okay?
And what kind of stuff is it that I'm supposed to be filling out?
It's going to be forms related to your application for disability benefits.
How does my disability have any effect on my child support?
Well, you just told me that you plan to meet your child support obligation by receiving disability benefits and using that to pay for it. So that's how it relates.
Okay, and what happens if they deny me again for a disability, which they've already done 4 times? The likelihood of them not.
You're gonna have to find another way to pay for your child support obligation.
Oh, there is no other way. I've tried all the ways. This was my last option.
Well, I don't know what to tell you. You're gonna have to find a
I
way.
don't tell you either, sir. I hope you have a great day.
Okay. All right, so Ms. Kraus, if you can set that hearing for 30 days, please.
Will do.
Mr. Hildebrand, did you have any questions at all?
I don't have any questions, but I also don't understand how she's not paying her child support when she's been to the bars multiple times and she can figure out the gas to get, dang near to Elmira, to my parents' house where she's not welcomed a few times this month. And it's just, I just can't fathom how she's doing what she's doing. And that's about it.
Okay, I understand. And like I've indicated, if she fails to either pay support or comply with filling out these forms, then again, the court's going to look at imposing jail time.
Yes, sir.